Before a creditor becomes a secured party, it must have a security interest in the collateral of the debtor. Certain requirements must be met for a creditor to have an enforceable security interest. Once these are met, the security interest is enforceable against the debtor by the secured party. We call this attachment. So attachment is the process by which a security interest in the property of another becomes enforceable. There are 5 requirements to an enforceable secured interest. First, we have to have an agreement in writing, or the creditor has to have actual possession of the collateral, which we call a pledge. Has to be signed. The agreement has to be signed by the debtor. Creditor's signature not needed. A reasonable description of the collateral must be in this agreement. The secured party must give some sort of value to the debtor. That's usually loaning the money. And 5, the debtor must have rights in the collateral. I think 1, 2, and 3 are pretty straightforward, but I want to talk a little bit further about 4 and 5. Let's say David already owes $5,000 on a previous unsecured debt to Sam. Subsequently, David signs a security agreement giving Sam an interest in some furniture owned by David. Would this create a valid secured interest satisfying requirement number 4, which says a secured party must give value of the debtor to the debtor? Yes. Security for total or partial satisfaction of a pre-existing claim does satisfy that requirement. So the giving of value doesn't have to happen right at that moment. He already gave value, so that could be used to later secure that money that's owed. Debtor must have rights in the collateral. That's requirement number 5, the last requirement. Ownership interest is sufficient or some right to possession of collateral. You don't need to require to have actual legal title. You just have to have some interest. So let's say Mary obtains a loan from bank to purchase a sofa, and she signs a security agreement granting the bank a security interest in any sofa that she will buy with this loan. Has attachment occurred yet? No, she has not gotten the sofa. She doesn't have any rights or interest in collateral yet, so it will attach when she buys the sofa. Roma applies for a credit card at Target. The application contains a clause giving Target a secured interest in any goods that Roma buys with the card until she pays for them in full. Do we have an agreement? Yes, the application. She probably signed that application. The description is the clause, right? Just reasonable. Anything she buys with the card at Target. That's going to be an adequate description for the collateral. Did Target give value? Yes, gave credit to Roma, whatever the max, I guess, amount would be on the card. Does the debtor have rights in collateral? Not until she starts buying product, buying stuff at Target. Let's talk about perfecting a security interest. In a security agreement, a debtor and creditor agree that the creditor will have a security interest in collateral in which the debtor has rights. In essence, the collateral secures the loan and ensures the creditor of payment should the debtor default. Usually, the creditor will repossess or take back the collateral because of debtor's default, right? If they don't pay for the car that they got the loan on, the creditor can repossess the car and then they sell it for the outstanding debt. But even though a security interest has attached, the secured creditor must take steps to protect its claim to the collateral in the event of a default, because there could be other creditors interested in that same collateral. So perfection is the method by which a secured party obtains priority by notice that his or her security interest in the debtor's collateral is effective against the debtor's subsequent creditors. Basically, this means they want to be higher up on the chain for collection. They don't want to be down below. They want to be able to go in and get that collateral so they can sell it and get as much money as they can for it. Attachment versus perfection. Attachment focuses on the rights between the creditor and the debtor. We'll have the secured interest attaching after those elements are met that we already discussed. Perfection focuses on the rights among the various parties that may claim an interest in the same collateral. A creditor wants to protect their interests. So how do they do that? Well, one of four ways: by filing a financial statement, they could be possessing or controlling the collateral, and then we have automatic perfection in one specific instance. The financial statement, I've already introduced the financial statement. This is probably the most common. The secured party files a completed financial statement with the appropriate state office. What is needed in this? Name of the debtor and the secured party, and then a property description by type and item. We do not need signatures. All you need is who the debtor is, who the secured party is, and a description of the collateral. This is the signal. I get first dibs. So we do not need signatures. We only need a debtor's signature on the security agreement. So where do we file this financing statement? As I said earlier, with the Secretary of State. There might be another appropriate government entity like a local or county clerk's office, where the debtor primarily resides or has a business that might require a filing, but most often it's with the Secretary of State. What's the point, though? What's the point of filing? This allows other creditors to look up to see if the collateral has been used as collateral for something else. So, for example, I have a tractor that I can use for collateral to buy a hay baler. If I do that, the creditor who's loaning me money for the hay baler will want to know if there are other secured interests against that tractor before loaning that money to me, so they can look it up and see. How effective, or how long do these filing statements last? For 5 years from filing, the date of filing, and it can be continued with an effective filing of continuation that must be filed within 6 months of the expiration. And as you can imagine, this can go on indefinitely until the debt is fully paid. Once the debt is fully paid, the creditor has to file a termination statement so that other creditors know that that lien no longer exists or that secured interest no longer exists. What if the financing statement is filed improperly? Well, if there are minor errors, we're not going to invalidate the statement, especially if it's not misleading. If we have a statement that's misleading, then it's not going to be effective. Things that have come up with invalidating the financial statement is when creditors attach extra papers to the statement, and then the statement doesn't refer to those. The debtor's name is wrong. This doesn't mean a typo. It means flat out wrong. If your name is Michelle, but you spell it with one L, but the statement has two L's, that'll be a minor error. Another big one is the collateral is not sufficiently described. It's confusing, it's misleading. That will invalidate the statement. I put perfection by possession and control in the same category. Possession is the secured party must actually possess it. Control is the collateral that cannot physically be possessed but is in control by the secured party controls it. So Clint needed some extra cash, so he took his saxophone to the pawnbroker. The pawnbroker loaned Clint $100 and took the saxophone as collateral. That'd be an example of possession, actual possession. Control applies to collateral that cannot be physically possessed, as I said. So electronic documents, deposit of accounts, investment property, things of that nature. Regarding possession and control, I have a question. Does a secured party have any duty when it controls the debtor's property? Can they just kick that fancy saxophone around? They actually have to use reasonable care to preserve collateral, and they can also charge a reasonable expense to do so. So let's say it is we'll go with the saxophone. Let's say it's worth more than $100, but Clint made a very bad deal and he was desperate for $100. And he said, but I'll be back. I'll be back in 2 weeks, and I'll give you the $100. I'll get my saxophone back. The dealer will have to keep the saxophone in a safe place. If it was an antique worth $1,000, he has to make sure it doesn't get kicked and dented and anything that would lessen the value of that saxophone. But if he has to buy, let's say he has to buy a special case to hold it in, he can charge that fee to the debtor. We can have automatic perfection on attachment. So once we have a written agreement, it's signed by the debtor, we have a description of the collateral in that agreement, the secured party is given value, and our debtor has rights or interests in that, or ownership in the collateral. Perfection is accomplished upon that attachment. This only is for purchase money secured interests for consumer goods, items sold on credit or by loan for goods bought for personal, family, household purposes. There are exceptions to this, motor vehicles, trailers, and boats. The Department of Motor Vehicles is usually involved with those. We won't have automatic attachment for motor vehicles, trailers, or boats. And that differs from state to state. New York recognizes this, however, this exception. Bob buys a refrigerator for his home from Friendly Appliance Dealer on credit. Friendly has Bob sign a written security agreement. So, do we have an agreement? Yes, I say it right. In the statement, I say it's written. Bob signs it. The description is that it's a refrigerator. The secured party is giving value. He's giving Bob on credit the refrigerator. And Bob buys, so he has rights. He has legal right ownership in the collateral. Do we have attachment here? Yes, we do, right? All 5 elements are met. Do we have automatic perfection? Yes, we do. Why? This is a purchase money security interest for consumer goods. Bob buys a refrigerator for use in a restaurant on credit from Second Source Bank. Bank has Bob sign a security interest agreement. Do we have attachment? Yes, we meet all of those 5 requirements. The question is, though, do we have perfection? And no, we do not. We do not have automatic perfection here. This is a refrigerator in this instance is being used for equipment. This is not consumer goods. So bank would have to file a financing statement to perfect its interest. As you can imagine, automatic perfection is not without its problems. I mean, when we have automatic perfection, we mean a party doesn't file. And the purpose of filing is to put creditors or even buyers on notice of a security interest. So when we have no filing, how are others supposed to know about it? Bob purchases a washer and dryer from Deere Appliances for use in his home, giving Deere a security interest. Then Bob sells the washer and dryer to Chris for a fair price for Chris's household use. Chris is unaware of the security interest that Deere has in the washer and the dryer. So the question becomes, does Deere have any rights against Chris if Bob doesn't pay for the washer and the dryer? And the answer here is no. Deere's perfection on attachment is not effective against Chris. Chris does not know about, Chris has no notice that there's any security interest here. So if Bob fails to pay, Deere can't go into Chris's house and take the washer and the dryer. Deere's recourse is against Bob, and we'll have to sue Bob for the money. There is an exception here. If Chris is aware of the secured interest, then he's no longer a bona fide purchaser, so he would take the washer and dryer subject to the security interest. So let's say B purchased the washer and dryer from Deere Appliances for use in his home, giving Deere a security interest. Then B wants to get a new washer and dryer. Doesn't particularly like the one that he's gotten from Deere, so he makes a deal with Chris, going to sell the washer and dryer to Chris for a sale price. Bob tells Chris, hey, I owe Deere on this, but once you pay me for the washer and dryer, I'm going to pay off the loan with Deere. And C says, okay, no problem. He trusts that statement. But then guess what? Bob does not pay Deere. He goes out and buys his new washer and dryer with the money that he got from Chris. So now what? Currently, there's no problem as long as B continues to pay Deere. But if Bob doesn't pay that debt to Deere, it's going to be Chris's problem because Deere can now come and take the washer and dryer because Chris is no longer, he knew about the security interest, he's not a bona fide purchaser. Going back to that example, Bob purchases a washer and a dryer from Deere Appliances for use in his home, giving Deere a security interest. Then Bob sells the washer and dryer to Chris for a fair price for Chris's household use. Chris is unaware of the security interest that Deere has in the washer and the dryer. What if Deere filed a financing statement anyway? Didn't have to. They have automatic perfection. But Deere, they've had these problems before, so they file a financing statement regardless of whether or not it's automatic perfection. This is going to be considered notice, constructive notice, even if Chris didn't go and look it up. Chris would take the washer and dryer subject to the security interest, and therefore Deere could then repossess the washer and dryer. The filing constitutes notice. Regardless of, it's up to Chris to check to see if there is a security interest in that collateral.